If you wanna say it loud, 'cause someone out there listening. If you're gonna think it, think out loud, 'cause you don't know what you're missing till you let them all in. Oh, oh, oh. Tell them what it's all about. Oh, oh, oh.
You're listening to the Divorce Registry podcast, talking about real people, real issues, and real solutions.
I'm Jonathan Fogel, a family law attorney.
And I'm Amanda Johnson, a family law paralegal. This is the Divorce Registry podcast, where we provide informative, entertaining, and invaluable insights into all aspects of family law. You can reach us at thedivorceregistry@gmail.com, and be sure to follow us on Facebook.
Amanda and I are partners at work and in life. We are both divorced, and we have 5 kids between the two of us. Some call it chaos. We just call it family.
We call it chaos too.
Yeah, you're right.
The signs say you'll be coming up rosy soon. It all comes back to you. It all comes back to you.
Hey, Amanda, how's it going?
Good, how are you?
I am good. Welcome, everyone, to the Divorce Registry podcast. Be sure to go to our Facebook page if you're not already there watching us, and like us on Facebook. And you can download us on iTunes or Stitcher or wherever you listen to your podcast. We'd love that. We're growing our listenership, which is fantastic.
You are actively watching it grow.
Yes, actively.
That is
too actively.
Your cell phone addiction is.
That is my newest obsession. I have like obsession of the week. Now it's Libsyn. I don't know how it's pronounced.
Yeah.
Libsyn.
I'm not sure.
Libsyn. Thank you. Libsyn. That's my new obsession. Is I watch I have 150 down. Now we have 200 downloads. Now we have 3, and I keep watching it grow. And I watch it'll show me what state people are listening in and what countries. It's exhausting.
We have a problem.
I know we do. The worst part is when I wake up in the middle of the night, to go to the bathroom as I do because I'm 50, and I'm like, oh, let me just check because maybe in the last 2 hours somebody downloaded us.
Yeah.
That's probably not good.
I know it's not.
No. All right.
No.
Well, I'll tell you another thing that's not good is that the last time I prepared a will was when my oldest son was born. So that was 19 years ago. Since then, I've had 2 other kids, gotten divorced, and am in a new relationship.
And I can beat you.
Yes.
I've never had one.
You
so
win.
I win. and now it's so inexcusable. It's inexcusable just to not do it, and it's also inexcusable that we work in an office where it's done and we haven't done it.
I know. It's like that story of the the roofing company that you go and visit their location and their roof is falling apart, or the driveway company and their driveway's all cracked up, right?
Yeah.
And that's what it is. I have talked about it forever. I tell my clients how important it is, not just to have a will, but a healthcare directive, power of attorney, all these other documents, and I don't know what's holding me back.
I don't know, and we need to do it because with our situation, we're not married yet. And
what?
Yet we it didn't happen while you were sleeping.
What?
But we need to address that. We need to, if we're going to be in our committed relationship, we need to know. And again, we are fine. That is a choice we've made not to be married right now because our kids come first. We have decided that living apart is best for them right now because it's too chaotic.
I think
Otherwise,
you've decided that, but okay.
I decided it first, and then you joined on the
After
bandwagon.
some tears.
No. But no, it would be important for us. Just as well as married people, we need it.
Well, right. I mean, actually, we probably need it more so than
Yeah.
married people. And we have an expert here today that's going to talk to us about
Yay.
this. Yay, experts. Because I'm not an expert in this stuff. And so that's why we bring on other people. So today we want to welcome Chris Tymchuck. She's an estate planning and probate lawyer. She's a partner at the law firm of Seiler Schindel, and she's the head of their estate planning department. Chris, thanks so much for coming today.
Thanks for having me, and I can do the proverbial "you're not alone."
Really?
As to make you feel a little better.
That does me. And I was looking at this, that it's at least the statistics that I found says that over 60% of adults don't have a will.
Correct. And Those that do, it's an average of 12 years, so you're a little behind.
You mean 12 years old?
12 years between wills, before they look at it again and update it. So,
And what is the suggested amount of time that you look at it? Is it you do it, you put it in a drawer, never look at it again?
I have heard anywhere from 3 to 5 years.
That you should do kind of an update.
Or at least review it. I send up a letter to my clients every few years that just say, have any of these things happened? It's kind of a 10-point checklist. Yes, divorce is one of them. Or contemplating a divorce might be a better way to put it, because you probably already met with a lawyer if you're divorced. But I have a little checklist of any of these things have happened. A birth, a death, a remarriage, a divorce, then let's talk.
Sure. And then how much do you get? How responsive are people to those things?
Somewhat. Usually it has to be a big thing.
Yeah.
A remarriage, a divorce, another child,
grandkids,
surprisingly, too.
Why do you think that is? I mean, do you think it's people are just, they don't want to think about their own demise? Is that what it is?
Yes, and I've actually heard if I plan for this, it will happen.
What?
And I've heard we're going on, this happens, it's very common, we're going on a trip. We're going to all be on the plane, so we should plan. But yet I feel like if I plan and we get on that plane, we just jinxed ourselves.
That you're kind of self-fulfilling prophecy.
Right.
My.
Okay.
Oh, my.
That's, again, I'm not making fun of anybody because I am in that same boat, right?
No.
And I don't know why.
I would say that I have just as hard a time sitting down and making my doctor's appointments, my yearly doctor's appointment. I don't even want to admit how behind I am on like my mammogram and all that. I mean, honestly, I will call today. But it's the same thing.
I think you said that yesterday and the day before.
I know.
But okay.
Right. I will. I'm saying it here.
Okay, we're going to hold you to it now. Everybody's seen you say that.
Right. The last
People,
someone's
if-
going to call in.
Yeah,
Did you have your
call
mammogram?
in, send a text message.
You do that on Facebook.
Yeah,
I was gonna say,
instant
put it on
message us.
Facebook Live.
Remind Amanda
Images.
to schedule her mammogram.
Oh, gosh. No, I'm just saying there's so many things going on, and you're making so many phone calls, and you're doing so many things for your kids, and you're doing... So when you get a letter from you saying you should look at this, it's like, yeah, I should. I got to do these things first.
Correct. And I do try. I don't want to be a pest. I try and follow up, but that's, I don't want to be a pest. But I have had a client who came to me and said, I need to redo my plan because I'm getting divorced. And I said, well, wait a minute. When we did your plan, you weren't married. So that plan's out the window, period.
Yeah, right,
Yeah.
right. You should have told me that before you got married.
Exactly.
And, yeah, right. Yeah. So, I mean, people hear this word estate planning, right? Or that, not word, 2 words, estate planning. What does that entail, right? Because I think of it as just, you do a will.
Correct.
But it's much more than that, right?
That is a really common assumption, and I tend to tell my clients that I feel like the will, in a lot of ways, is the least important document that you can do. I feel like a healthcare directive, so that someone can make your decisions with your help and instructions, and the power of attorney, which is the financial matters, are the most important. We get a lot of clients where mom or dad is aging, they need some assistance in their affairs, and instead of just adding the child to your bank account, because there's all kinds of problems with that, or to your house, get a financial power of attorney so that they can make those decisions for you and act on your behalf without any of the repercussions of just adding someone to your account. So I also tell clients, for me, the will, let's face it, you're dead. When it takes effect, your power of attorney and healthcare directive, you're still alive.
Right.
These are things that actually happen
Affect
to you now. And you could be sick, you could recover, and you want to make sure that things were taken care of to your specifications when that happens.
Well, and also, I look at a healthcare directive, and again, I'm guilty of this, and I'm thinking of my kids or my brothers or whoever else, that if something happened to me and I was on life support or some major decision needed to be made for me while I was alive, if I don't make my wishes known, then I'm really dumping that burden on them.
Right.
To try to decide, well, geez, what are we going to do with Jonathan, right? And we don't know what he would have wanted, and then that puts that huge burden on them, and they have to feel guilty. Did
Correct.
they make the right decision? And so doing a healthcare directive can be a wonderful thing to take that responsibility off whether it's your friends, your family, whoever it is going to be making those decisions, your spouse, as somebody else.
Correct. And you have like kind of the perfect storm in your relationship, because if you didn't have or don't have a healthcare directive, it's your kids, because you're not married,
Right.
and you have multiple kids, so they would have to get together and agree.
I choose Isaac.
Actually, someone would have to go to
He's
court.
the most responsible.
And you could choose him, but you would have had to write it down.
Darn it.
In a healthcare
Okay,
directive.
so saying it right now, that doesn't count.
No.
I picture some like
Isaac would be sitting on his Fortnite
No,
being
no.
like, okay, let's hook up Dad.
well, and I picture he'd be in there with the DJing and like doing like I don't know.
And this is
like,
why I pick him.
right.
Because he would
You would
think
go
of,
out in style.
Right,
Yeah.
not only would I go out on style, but he would figure out some way to like download some kind of program to keep me going into the Fortnite game.
Depends
or
on what your
something.
will says.
Oh shoot.
Oh,
Okay.
boy.
So basically I have to come up with something and do something.
You come up with something.
Okay.
And when I work with clients in probate after someone's passed away, I've had several of them who said that the healthcare directive was the single most important document from their perspective because it told them what their spouse, partner, parent wanted, and they felt at peace as much as they could in making those decisions that they knew that the person had chosen. So they felt like he said, I'm never going to be intubated. It's not my choice. But I followed his wishes, and I feel peace at that.
Okay, so what really happens then when you don't have those things? I mean, like you touched on it, but what?
Correct. So if you don't have a healthcare directive or a power of attorney, which are, one handles your medical decisions, one handles your financial, then someone has to go to court to get the right to do it.
That's what probate is.
That's after death.
Okay. This is when you're right. Okay,
yeah,
gotcha.
the guardianship, conservatorship. So
is
someone
why I
goes
don't
to
do
court
these
and
things.
says, right, that's why you bring on experts.
That's why you're with us.
Someone says, I want to be the one that makes Jonathan's healthcare decisions. And the court, of course, says, why should it be you? And then there's a process, which can be expensive if someone said.
And time consuming, I imagine,
right.
too.
If
as
Amanda
you're
says, no, it should be me, now what?
Right. And then as that debate goes on, you're not getting necessarily the care that you need.
Correct.
Or the decisions aren't being made that need to be made.
Correct. And the other piece of that is I talk to clients and family members. Let's admit my clients are family members. Is this where you want to be? Jonathan's in care. You want to be at the hospital with him, correct? You don't want to be in court. You don't want to be in a lawyer's office. This is the worst time for you to be going and running around going to banks, doing these other things, when you'd rather just be there caring for him or sleeping, showering, and eating.
Yeah, right. Taking care of yourself
Right.
and
Self-care.
Yes, self-care. Exactly.
Self-care.
Yes. Yes. We can get him Julie's book.
Go back to our previous podcast.
Right.
Yes. Well, one of the things that I was going to ask is my son now is 19, right? So he's at college. What if something happened with him now that he's an adult? I use that air quotes.
Legally.
Legally an adult. No, I'm just kidding. He's very responsible. But if something happened to him, what rights would I have without him having a healthcare directive or without him having power of attorney or those kind of things, right? Not if he died, God forbid, but if something happened, he's in the hospital, I had to go down to school and figure something out or take care of him. Do I have the ability to do that without those documents?
So you do if he's awake and alert and can say you do, which then again, you don't need the documents at that point because you're always in charge of your own health care until you're not. So he can make his own decisions to let you visit. But if he's unconscious or in a coma, as you said, God forbid, then no, you can't. I've had clients who told me that their children, one was in Atlanta, and he was in an accident, and they had to put him in a medically induced coma. He recovered and is fine, but she flew down there, and they said, sorry, you can wait, out here, and we'll come out.
Wow.
But we can't tell you anything. That our privacy laws are so strict now that they said you can't make any decisions for him.
That's really scary.
It is, and I think a lot of people don't realize that when they send their kids off.
It makes sense, though. There's some kids who, God forbid, may have not wanted to be part of their parents' lives when they turn 18 and wouldn't want them making a decision. So
Correct.
That's right. I mean,
Yes,
that's why.
there's two sides to that. Exactly.
Okay.
Yeah. And so healthcare directive, big, I mean, for not only yourself, but for your family members,
Right.
for other people, because again, it's not just, okay, I want one for myself to make sure other people can make the good decisions, but also for my family members so I know what their wishes are.
Right.
Right? And so other than, okay, so we got the healthcare directive, power of attorney, wills. In other situations, so when people get divorced, right? A lot of the people that are listening here today are either thinking about a divorce, going through a divorce, have been divorced. How does a divorce impact someone's estate plan as with respect to the will?
Right. So in Minnesota, we have a law that says if upon the finalization of your divorce, your ex is pulled out of your estate plan, it's as if they predecease you. clients love that term when they're divorcing. It's like they already died. They're like, that's awesome.
Oh,
I love it. So yes, it's as if so it goes to the next person. So if you had listed your spouse and your child as a backup and you divorce, then it goes to the child. The tricky part can be, I think, guardianship. Do you and your ex still agree if you're both gone on who could be the guardian?
Sure.
So if I picked my spouse's brother, who I never really liked, but I gave in and did that, and then we divorce, I'm like, if I'm the last to go, no way does my kid go to the brother. So
Right.
you would want to change that and pull them out. And also, I have clients who will come to me after a divorce. It's just like, I want her name off every single document I've ever seen or will see. So can you just update it to do that? I understand the law does it. I don't care. I want their name
Right,
out.
you want it off anyway.
So they do get
And that's
pulled
just a
out.
Minnesota thing.
That's
Other
just
states have
Minnesota.
different laws.
Yes.
Because people are listening to our podcast all over. We're in,
Correct.
just so you know, 17 states and the Netherlands.
Not that he's tracking.
Not that I'm keeping track, but I think I just saw another
Excessively.
download
2 in the
as
morning.
we're talking. 2 in the morning. But so is the law regarding estate planning, wills, succession, is that individual states, or are there federal laws that also cover those things?
It's individual states for the majority of
Okay.
it. There
So-
are some federal qualified retirement account laws, but we can disregard those for this purpose.
Okay. So just so people know, if you are dealing with a will, you want to make sure you check with an attorney that's licensed to practice in the state that you live in,
Yes.
because there are definite changes or definite differences between states regarding these rules.
Yes.
Okay. The other thing I wanted to ask you about was beneficiaries.
Yes.
Right? So when people are getting divorced, a lot of times in their divorce decree, it says they either have to continue to name someone as the beneficiary of a life insurance
Right.
policy to secure their child support or alimony or spousal maintenance, or it says that they can change the beneficiary, allows them to do that. So what if someone doesn't name the other person as the beneficiary, right? For example, I pass away, I'm supposed to name my ex-spouse as a beneficiary of the life insurance policy, but I never did. And I pass away. What controls? Is it the will, or is it the decree that says I was supposed to do it, or was it the actual policy itself? And what happens?
That would be the decree. When you're going to end up in a lawsuit there. I mean, there's no way
I won't,
around
'cause
that.
I'll be dead.
Right, you won't be dead. But your heirs
Yeah.
are going to end up in a lawsuit, which of course is like, do you really want your surviving spouse and your kids maybe steps in that kind of a battle?
Arguing over that.
Right.
About
Maybe you were the thin thread that held their relationship together while you were alive, and now it's gone. But that's going to be a battle, and I see that in my planning because they come to me after they're done with you, and a few years later they want to update something, and I say, well, what about this life insurance? Do you need to keep it?
Sure.
And they'll show me the dissolution decree, and I'll say, well, it says right here, have you checked?
Right.
Do you have it, and have you checked on your ex to see if they have it? I'd say so far I'm batting 1,000 that none of them have done it.
Yeah.
But obviously, if they do pass, that's going to be an estate battle. They're going to fight the estate for that money because they were supposed to do it. The decree would take over at that point.
Right. And what we do when we write our decrees, what we have in there is that not only is the person required to do it, but we write in there that the person that's supposed to be named as the beneficiary also has the ability to check on that, not just ask the other person, but usually an authorization of some sort to go directly to the insurance company to make sure that they're still named as the beneficiary.
Correct.
And sometimes we even require that the person that maintains the policy has to provide proof of that on an annual basis or a biannual basis or something else. Because like you said, if they pass away, you're in a lawsuit. The insurance company, what do they just pay it into the court or something, and then it goes through probate, or does it?
And that's a best case scenario. That's a scenario in which they still kept the policy, but they didn't name the ex as the beneficiary. The worst case is they just let it lapse.
And then they have a claim against the estate.
Right,
Yes,
and the
yeah.
estate better have money.
Right. And if it
And what if it
doesn't,
doesn't?
then they're SOL.
Or if
essentially.
they have, in probate, there are certain assets that are exempt from creditors. What if it's an exempt asset that you can't go after? So the situation I've seen, they didn't have it at all, and we had to talk through it. And I think one of my things I always say when I present are, these are some things you should do right now. Checking your beneficiary designations is always one of my top things. But I would add that to that list of beneficiary designation. If you have a divorce decree, if you're divorced, check to see if it has that, and then make sure you put a tickler on your calendar, every year to verify they're keeping it.
just keeping it up to date.
Because that could be catastrophic if they're supposed to keep it to it's to cover the child support
Right.
you're receiving, and they pass away and they don't have it. Now what are you going to do?
Right.
And what about, there's, for people that are married, is it necessary for them to have a will? Doesn't everything just go to their spouse
Well,
when they die?
Well, there's two different ways to look at that. But when you have a will, you still have to go through probate. This is a big myth. It's actually on my list of myths here, is that people think I have a will, so I don't have to go through probate.
That's what I thought.
Yeah.
A will is an instruction to the court for what you want. Probate simply means you have to go to court. I know there's a lot of, I hate to use the word because people get confused by what it means. It just means the court's involved now. So how does the court know what to do?
Is that where everyone goes and sits down and the person puts in the videotape and it shows?
VHS.
I see that in a lot of movies. That's not what
It would
happens.
be awesome if my job were that
That would
exciting
be
and
right.
dramatic.
And everyone sits down like
a little old
and,
guy.
Yeah, and Jimmy left his so and so to you, Aunt Betty.
Yeah, right.
That's not what it is.
In fact, even though
That's what I think of probate.
You also see all these things that are like, here's the steps in probate. Have the lawyer read the will.
Yeah.
Can I tell you how many times I've read a will?
You don't really?
Zero.
Oh, that's
Yeah,
so
right.
To the
disappointing.
client, I read them all the time because I write them.
I was
but
gonna
to the client, I don't read them. I'm like, here's your will. But I've never sat down
That
and
is
like
so
read a
disappointing
will
to me.
a client.
I thought you'd like sit in like this room that looks like a library.
chair.
And, yeah, the dark room, and everyone's sitting around you, and here's Chris, and reading out the will, last will and testament. No, that's
They
not
would
it.
fall asleep.
And you
about
hear
2
gasps.
paragraphs in.
Yeah,
Right.
right.
Right. Pay the death expenses. What
Right.
does that
Yeah.
mean?
Wait, I didn't get the car. You're sobbing. And,
That'd
no,
be awesome.
That's not what it is.
No, it's actually even it's so informal for the most part here. We submit the will to the court, the paperwork. It's all electronically filed.
That's no matter what.
It's so
in
less
any
dramatic
case.
now.
In any case where someone dies, that's what you need to do.
We can I don't want to get too far in the weeds, but in Minnesota, they have to have either real estate or $75,000 plus in probate assets.
Okay.
And that probate assets means they aren't going by beneficiary designation. They aren't jointly titled. You don't have a trust. You don't have a payable on death account that says, upon my death, pay it all to Jonathan. That doesn't go through probate. This is an asset in just your name.
Got it.
And then it's not in a trust. It's not in a business. And then you pass away. So you need a certain threshold before the court wants to be. They're too overwhelmed.
And
right now.
how much does the court get involved? I mean, I know it like with Prince, right? I mean, he didn't
Right.
have a will, so
Right.
that litigation I think is still going on. Aretha Franklin didn't have a will. I mean,
Right.
it's amazing all these people that have all this money that never put together
Right.
wills, right? But if you do have a will and it has to go to probate, how long does that process usually take? Unless if someone's not contesting
Correct.
the will.
So you're basically going to get someone appointed to handle it, which is called a personal representative / executor. So that process can take about 2 months to do that. And that's to
Even
get
if it's
someone
named
appointed.
in the will.
Yeah, because there's a series of steps you have to go through. So it's
make it
30 to
legal.
60 days to get that done. If you have to have a hearing, so if there are any issues that come up at all, and I don't mean a contest, this can be, they do sometimes automatic hearings when there are step kids involved, just automatically. And,
Okay.
and I've gotten around that by going to the court and saying, no, this family gets along. I promise there won't be any issues. They've let us get away without a hearing. With a hearing, our hearings are 2 months out. So now you're looking at 3 to 4 before someone has the right to act. That's just getting someone to be able to go get that bank account, to sign the deed to sell a home.
Is the idea because the court essentially is kind of sitting in the shoes of the person that passed away and they want to make sure that everybody is acting appropriately according to what the will says? Is that kind of the idea?
It is. Their main involvement is, at the beginning, is why are you going to be the person who is the executor?
Sure.
That's a term everyone understands. Why is it going to be you? Once we've appointed you, we're kind of out of it unless someone comes to us and says, Jonathan didn't do what he said he was going to do. They aren't involved with, if you're the executor, they're not involved with, except in extreme cases, with did you do this?
Right.
Unless Amanda comes forward and says, Jonathan didn't do this, now I want to have a battle.
This is a little bit. You can compare it to when we have cases that where we have a final judgment and decree, and we don't have the other person wasn't represented,
Sure.
and we were representing our client, and therefore they make you go in for what is called a default hearing. Right? The judge wants to make sure when there's kids involved.
Right,
Sorry,
when
when there are
understands.
want to make sure, and that's all they're there for. Is just to
Yes.
question quickly and just make sure.
Yes, so that if there is a hearing, it's basically I want to be personal representative, and so does my brother. Then there's a hearing. That's simply to determine who's going to be the personal representative. They're not making any judgment calls on
They don't get into the
where
minutia.
the assets go. No.
Unless someone comes in and
Unless someone
says,
comes and
wait a
says
minute, they spent $100,000 on
Correct.
themselves, and that wasn't what the money was supposed to be
Yes. So that's the court's not hugely involved unless, in some cases, if it's a supervised probate, we call it here, and that means there are some issues. Or a lot of times, if it's there's a lot going to a charity, they want to oversee it. I had one where it's a stepchild was the last survivor, and he never did a will or anything, but he raised her since she was little. He had wanted to adopt her, but her biological father fought it, so he didn't. He passed away. There's the assets in the house she grew up in. He has no relatives whatsoever. They had to go to Russia to search for relatives. So in that case, the court wanted to be involved because there isn't anybody. So if no one can say, did she do what she's supposed to do with this? So then she did have to go with court involvement. But that's kind of an extreme case.
Well, but I think it raises a really good point of blending families, right? Because we deal with that a lot. Amanda and I, deal with that in our own lives of blending our two families together. But if Amanda and I blend our families and we get married, her children don't have, unless I have a will, they're not going to inherit the things that I have. It could go to Amanda as my spouse. Is that correct? I mean, because they're stepchildren, they're in a different category as my biological children.
It's actually trickier. It is correct that Amanda's children don't get anything because
that's all I wanted to know.
I'm just correct.
I love your children.
But
shape up reasoning.
Because the legislature figures Amanda will leave it to them, right? So if you leave some to her, and
Right.
she'll leave it to them. But what they do is they take care of your children. So if you don't have a will and you pass away, Amanda gets the first $225,000 in Minnesota-ish, plus some other assets, the right to the home, automobile, blah, blah, blah. Everything else is split between her and your kids 50-50.
Okay.
And that ends up
Because
being
they
an
assume that
issue.
she will then take care of her own children.
Correct. But that she won't take care of yours.
Right.
That's the other
I
assumption
see.
here. That she's going to be like, I got my money, see you later.
Right.
And then it's now it's come out of your family. Like, say you had a family cabin.
Right.
Where did it go?
Right. And my kids. So the idea is that they not only exclude her kids, assuming that she will take care of them, but they also say we don't trust that she will take care of your children.
Correct.
So they're going to get 50%, and that's if we don't have a will. If I have a will, and then I can
Yes.
say who's going to get
Yes.
what and who's not going to get what.
Right.
Because I imagine a lot of people put wills together not just to make sure certain people get things, but also the opposite. So certain people do not get
Correct.
things. Is that right? I mean, you probably see that a lot.
A
that
lot. And
I don't like my
I
sister,
don't want this
or
person.
I don't want,
And I have built my practice on more complex planning. And when I say complex, I don't mean like $50 million estates. I mean these situations, because that's what I've built my practice doing. And so I work with a lot of clients who want to disinherit somebody or want to limit what they get. They may not disinherit them altogether, but they may just say, well, I want them to get a certain amount, but only for education.
Right. And is it that hard? I mean, I think of it, again, I don't do estate planning, but I've seen a lot of movies, and watched a lot of TV shows like L.A. Law and things like that. So I feel like I got a really good education.
Oh, we need big shoulder pads.
Yeah, that's right. Wasn't that Corbin Burnson? I think, right?
Uh-huh.
Oh my gosh.
But is it hard to disinherit somebody? Because my understanding from law school, right? This is my rudimentary understanding of estate planning that I had to take that course in law school. That certain people are entitled to intestate shares of, or of the estate, right? Your wife. You can't exclude your wife completely from your estate plan. Is that right? Or certain people?
So in Minnesota,
I know different states are different.
Yeah, and I
right?
think is it Texas? I think there's a state that doesn't allow you to disinherit kids, but don't quote me on that because I don't know the state.
Yeah.
But we don't have that here. But it's very difficult to disinherit unless you have an antenuptial agreement or prenup, which more commonly called.
Right.
But it's difficult, but it also depends on the number of years you've been married. There's all kinds of factors that your spouse is entitled to a certain amount of assets, and then they can choose to go with the will or to
take a different share.
Take a different share.
Okay.
Correct. And so I believe a lot of states have that law that you can't. And I actually have had this happen several times in my practice in probate where women have come to me after the spouse has passed away and turns out he tried to change his estate plan. They've been married for 20 plus years. All of them changed his estate plan to leave everything to his kids from a prior relationship. So her stepkids.
Sure.
Even though they'd been married 25 years.
And she didn't know.
No. I mean, we're able to get it back for her,
Right.
but she has to spend money and go
Yeah.
to court to do this anyway. So that was kind of a
here she's
slap in the face.
Maybe she is, maybe she isn't grieving her husband's death. In that case, maybe
Less
not so
so
much.
now.
Right. Less
Yeah,
so. But like you said earlier, I mean, is that where people want to be?
Correct.
When they've just lost somebody that they care about, right?
Correct.
And so I look at it as, again, I'm going to, punish myself here as I tend to do, but not putting a will together is really not fair for my kids. I mean, to put that on them and be like, okay, not only did I just pass away, now you got to figure all this stuff out yourselves. Good luck.
And I get a lot of clients who just came from being the executor of an estate and said, no way am I putting my kids through what I just went through handling mom's estate, dad's estate, brother's estate. Nobody else would do it. I stepped in. It was a mess. And now I want to come and have you fix my plan so that I don't have to do this because it's time, it's money. Part of the issue we end up a lot with here is, the biggest asset's the house. And maybe there's a little bit of cash, maybe not. There are beneficiary designations, so that money just gets paid out.
Right, on the retirement
who's
accounts and things like
paying
that.
for the probate?
Yeah.
Who's fronting the $5,000 retainer to get? They get the money back if there's
They-
money
from-
to
if
pay
there-
them
if
back.
there's money.
Right.
Correct.
Right.
And I had this situation just yesterday with a new client of she's going to have to put it up because her 4 brothers and sisters are deadbeats and aren't going to do it, but there's just a home. So what is she going to do? Just front it till they sell the home and get the money back.
Right.
That's a best case scenario. Put it on a credit card and then, recoup it later. But they've already paid funeral expenses now and things like that. So,
And a lot of people, I imagine, they're not in a position to put up
They're
$5,000
not.
or any money at all. They're like, well, what are we going to do? There's there's
Correct.
a lot of debts. There's a lot of
They may have just paid for care for the person who died.
correct. And the funeral usually, because before they come to me, they've already been, handed over a credit card for the funeral.
So you mentioned some myths. Did you write a
Yep,
few down? I'd
I
love
did.
to hear some. Yes, tell us some myths about estate planning.
So one of the myths was that will doesn't equal probate. So that's kind of the top one. Another one is that you touched on a little bit earlier is that married people don't need to plan. I hear this, and especially I work a lot with the LGBT community. And when the Obergefell decision passed and marriage was the law of the land, I actually had 3 or 4 clients call and cancel their consultations with me saying, well, I'm going to get married now. I don't need you.
Yeah, 'cause I used to write cohabitation agreements
Yes.
before.
Correct, yeah.
Before there was a lot.
Those are fun.
Yeah, yeah. Right. There were so many. I'm not going to get into the
I know.
nuances of those, but that was what you had to do because
Right.
people that were same sex that were not married, they couldn't marry. You had to write basically an agreement on how they were going to divide things.
Correct.
Because they didn't have any legal interest in each other's
No,
property
and
at
they
all.
would have to be in civil court
Right.
for that, not
and
family
it was a
court.
nightmare. So
Yeah.
now that they can, that the LGBT community can marry, that you feel like they're saying, oh, now we don't need a will.
Oh, they did. Flat out said it to me. So, or I've actually had one that came and said, well, what's the difference if we'll get married? And then a week later, they wrote me and said, we just got married. But you still, married people, straight people have been planning for a long time.
Right.
So it doesn't really mean anything.
Right.
So there is that belief that if we're married, we don't need to. You have the stepkid thing. You also have, there's almost every single client I work with, if we go down the line of intestate succession, that means you don't have a plan. It goes down to kids, grandkids, up to parents, to siblings, up to grandparents, to cousins.
I remember that chart
There
from
is
law
some,
school.
Right, the chart goes out forever. Minnesota's really generous. Some states aren't. They go to a cousin and then you're done. Here, they'll look forever. So there's somebody that you don't want to Uncle John.
Right.
So there's that.
Damn Uncle John.
And then trying to find a way to avoid probate altogether because, we haven't touched on some of the other things you can do, but having a trust or having your beneficiaries in line. So I think that the idea that if I have a will, if I'm married, I don't need a will. If I have a will, I don't need probate. Those are 2 of the biggest myths. And then
Let me touch on one before you get to the
Go
next
ahead.
one that I see a lot is people naming their minor children as beneficiaries.
Yes.
Right. I see that a lot when people get divorced and they have to maintain a life insurance policy.
Right.
I say, well, just you got to name your spouse. I'll name my kids.
Yes.
Big mistake, right?
I'd say 90% of clients that come to me that have a minor child have named their child. Minors cannot inherit, so they have to put it in a trust account to be held for them, somebody has to volunteer to come and be the custodian for that account and go to court and get approval for paying the money. And then depending on the way it's structured, they get all of it at 18 or 21.
Yeah, and I know if I had gotten a huge amount of money when I was 18, it would have been gone by the time I was 19.
For sure.
I mean, for sure.
Right.
So is that really what people want to do? So having you name an adult or name somebody who's going to be the trustee of that money to make sure they can put it out. So what other myths do you have? I know we're running short on time. I'd love to hear what
estate planning is for rich people. I hear that from people. I don't have an estate.
Right.
I'm not Bill Gates, so I don't have an estate. And now we know rich people don't even do it, Aretha Franklin.
Right.
So I think the term estate, I don't like it because people think, oh, that's like a big mansion and I have lots of money. And I try and convey that estate is your kids. Who's the guardian? Your estate is your home. Most people have a home. Your retirement accounts, your life insurance, your car, everything goes into an estate. So you do have one. It's a matter of whether you want to be the one to make the decision as to where it goes.
Sure.
And if you want to make it as simple as possible for people who've survived to manage it.
My last question for you is if let's say my not let's say because it's true, my ex-wife and I, we have 3 kids. 2 of them are still minors. If I name the guardian in my will, but she has a different guardian named in her will, how does that get decided on who's going to be the guardian of our kids if we both pass away?
I think if you pass simultaneously, you'd have a problem.
Okay.
But if you predecease her, I would think her will would control at that point because they're now going to look at her will.
Okay. Because I get this question a lot from clients like,
Yeah.
hey, I don't want my ex to have the kids. I want someone else to have them.
Correct.
Can they put that in a will, and can that be enforced?
And I just recently had a case where a family law attorney referred someone to me because his wife had developed some mental health issues during their marriage, and they got divorced, and they had I think a 2 and a 4-year-old, and he got sole legal and physical custody, and she gets supervised visitation, very strict. And so we wrote that into not only the will, but we got a temporary custodial designation so that if he passes away, he could name who gets them immediately so they don't go into Child Protective Services. They don't go to her for that 90-day period while they figure it out. We referenced the court order so that it was clear immediately that there is a reason here. So we put that in the will and in the standby custodial designation to do the most we could do to cover him on that.
Great stuff. I wish we had more time, Chris. This is great information. We will.
You know where I am.
I do know where you are. We'll put a link to the Seiler Schindel Law Firm on our Facebook page. And please, if people have questions, send us an email to thedivorceregistry@gmail.com. Great show. Thanks
you.
a lot, Chris. Thanks for
guys.
coming. Yeah, have a great day.
If you wanna say it loud, 'cause someone out there listening.
The information in this podcast was for general purposes only. The information provided was not legal advice or a legal opinion. You should seek the advice of legal counsel of your own choice before acting upon any information from this podcast. Contacting us by phone or any other means does not establish an attorney-client relationship.